But in any event, I approach these issues principally from the perspective of someone who practices employment law almost exclusively with respect to private employers. And for people like me, these cases that have been coming down in the past few years have generated a good bit of shifting sand. DE&I programs and policies have been around for a long time. In fact, they have their origins, I think, in the late 1960s after the passage of the 1964 Civil Rights Act, when a number of companies hired consultants, anti-discrimination consultants, to teach them how not to be sued under new laws that said race and sex discrimination was illegal under the 1964 Act. And those efforts, those consultancies grew over time. And by the middle of 2020, most big companies in America had established DE&I programs. They had established DE&I staff. They had established DE&I policies. This wasn't really a mystery to many folks. But then with the death of George Floyd in May of 2020, all of that sort of exploded. And folks like me started getting calls all the time from people who wanted to create and expand and fortify their DE&I programs. The position of diversity consultant or DE&I consultant proliferated like mushrooms after a rain. These issues were in discussion all the time, and we could not even keep up with the demand on DE&I policies and programs. Then the backlash started, and all of that culminated in the Supreme Court's college decisions in 2023. And suddenly people like me started getting calls from the same employers with different questions. What do I do now? What does this mean about the future of our DE&I programs and policies? Can you please take a look at my programs? In some cases, can you pare them back? In some cases, can you eliminate them entirely? These employers felt like they had been the victim of a profound case of whiplash, where it used to be you could do pretty much anything you wanted within the umbrella of DE&I, and now it seemed like you could very little. So the general advice I give these employers, as a lawyer who counsels private employers, is to lightly paraphrase Mr. Twain and say the death of DE&I is exaggerated. Perhaps not greatly exaggerated, but it is exaggerated. There are a number of valuable programs and policies that were born by the DE&I movement, I'll call it, that remain valuable, useful tools for employers. And we need to identify those as lawyers. We need to retain those, and we need to counsel our clients how to use them properly and with minimizing the fear of liability or risk. But we have to be careful to separate those useful DE&I tools and policies and procedures from what a good friend and law partner of mine calls DE&I foolishness. And we have to make sure we don't throw the good DE&I babies out with the DE&I foolishness.